This is Bruce Wall from the City of Scottsdale's Neighborhood College Program. We're all in this together.
The City of Peoria. We're in this together.
The City of Chandler. We're in this together.
Hi, this is Jamie from the City of Scottsdale with my daughter Jocelyn. We're in this together.
City of Tempe. We are in this together.
So happy to have you here with us today. First, before I forget, happy belated Veterans Day to all of our veterans. Thank you so much for your service to our country. Without you, we're land of the free because of the brave. So thank you so much. I'm sorry that's a little bit belated, but and I'd also like to wish everybody a really happy Thanksgiving as we're approaching Thanksgiving here, and hope that you have a wonderful holiday with your families. Good morning and welcome to class number 11 of our 2021 virtual HOA Condo Academy in partnership with the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, and Tempe. Thank you so much for your partnership on these virtual classes. Since March of 2020, we've had some phenomenal attendance and provided free education. And I think we're at over 40,000 views of all of our videos since the pandemic started in March of 2020. So congratulations to all of these different cities who have really come together, worked together. Together we are better in providing these classes that are free and virtual for the residents of these different cities. My name is Beth Mulcahy, and I am the managing partner and senior attorney for the Mulcahy Law Firm in Phoenix, Arizona. I have enjoyed representing as legal counsel for condominiums and planned communities for the past 25 years. I had my 25-year anniversary of starting my firm on November 1st. And it's gone by so fast. I can't believe it. 25 years has been a blink. And it's been a wonderful time working with so many different associations, thousands of associations in Arizona, and working with the different neighborhood services departments from all the different cities that are partnering with us here today. It's been my pleasure. To date, our firm has now hosted 44 virtual seminars since the pandemic started in March 2020. I'm so proud to tell you that our virtual classes have been viewed by 47,000 different views. And that is just incredible. So thank you so much to all of you who are here today. It looks like we have about 80 people on the Zoom call, and I know we have people joining us on Facebook Live here today too. So thank you for being a part of these classes and for wanting to learn more about your associations and the law in Arizona to create better communities. Okay, so I'm going to be sharing with you shortly here our firm's website at mulcahylawfirm.com and also our firm's LinkedIn page. The reason why I'm sharing this is because I just wanted to mention that all of the videos that we've taught since the pandemic are listed on our website. And you can rewatch them again if there's something that you learned today that you want to show somebody else on your board, or you want to just go back and have a refresher. Truly, with so many different virtual seminars, 44, there's practically almost every area of Arizona association law is covered. So I encourage you to go back and look at those if you have any questions or you want to show something to somebody on your board. Okay, so what are we going to discuss today? In today's class, I'm going to give you an overview of the most important things that board members need to know to serve on their board. And this class not only applies to board members, but it also applies to managers and homeowners too. Because maybe you're a manager for an association and you're concerned because your board maybe isn't doing things properly and you want to get them on the right track. Or maybe you're a homeowner and you're concerned or upset because you think that the board isn't handling things correctly. And so this class is a great learning opportunity for everyone to find out what exactly are the responsibilities that you have when you're serving on your board, and what are the laws that you need to be aware of so that you are able to continue serving on your board without having any legal issues. We're also going to cover how to amend your documents. As you probably know, We have a 5-step plan that our firm has, coined, so to speak, and has been very helpful and instrumental in helping associations amend their CC&Rs, their bylaws, and their rules in the association, also their articles of incorporation. And so I'm going to share with you today our secrets for how we came up with the 5-step plan and how you can successfully navigate amending your association's documents. So just a point on amending documents, remember that many associations in Arizona were created in the 80s, 90s, early 2000s, and really your association's documents do need to be amended about every decade. Why? Because there's changes in the law, there's changes in the operation of your association, maybe your developer is long gone, you don't need that language in there anymore. And so you want to just keep up with the times, so to speak, and make sure that your documents are updated for, year 2021, and that it doesn't contain language that violates state and federal laws. Okay, first things first, I always like to know who's in my audience. So the question is, in which city do you reside? And we have 10 different options. Avondale, Goodyear is number 1, Chandler 2, Glendale 3, Mesa 4, Peoria 5, Phoenix 6, Scottsdale 7, Surprise 8, Tempe 9, and other would be 10. And then we also have a second question. So we got a little double header here. Let me know what your current role is in your association. Are you a board member? Are you a community manager? Are you an interested homeowner who's not a board member? Or are you just joining us here today as an other, or you don't want to share with us, what category you fall under? So it helps us if you participate in this poll because it helps us tailor the classes best. Okay, so it looks like today we have 11% from Chandler, 3% from Glendale, 11% from Mesa, 5% from Peoria, 8% from Phoenix, 30% from Scottsdale, 2% from Surprise, 3% from Tempe, and 27% from other. And then in terms of who our current role is, we have 75% of you are board members today. 13% are community managers, 10% are homeowners, and 3% are other. So that's a really great sprinkling of cities that are represented today. And also we have somebody from basically every category, board members, managers, and homeowners. So thanks for being here today. We're going to dig right in to our class today. And the first topic we're going to talk about is duties and responsibilities of board members. So we have a great cheat sheet on duties and responsibilities of board members that my office is going to be sharing with you here shortly. And for those of you who may not be familiar with our cheat sheets, these are probably a 2 to 3 minute read. It's just a one-page document that takes a subject and briefs it for you, basically, like a legal brief on a topic. So one of the first ones that we ever created was board members, roles and responsibilities. It's truly one of our most popular sheets. It's something that we give to new board members, something that we distribute to management companies so that they can pass them out to their board members. Great refresher for current board members, even if you've served on your board for a long time. Basically, it's just the 411 on everything you need to know about serving on your board. Okay, so let's dig right in. So remember that when you're elected to serve on your board, even though it is not a paid position, you're a volunteer, you are looked to by your members to provide caring leadership and service that's going to make living in your association desirable. The board of directors is overseeing what might be one of the largest assets somebody has, their home. And so you really need to be mindful of running it as a business, running the association as a business, treating people respectfully and fairly, following Arizona law and federal laws. And then just kind of one more plug for conducting yourself in a professional and business-like manner in all your dealings with homeowners. Okay, so let's talk a little bit about what are some general responsibilities for board members. The first thing is kind of an easy one. You have to play a participatory role. You have to attend board meetings. You have to arrive on time, be knowledgeable, understand, and if necessary, research board issues, and be ready to discuss and vote on such issues. So really, if you're going to serve on your board, you have to be involved. You have to show up for your board meetings. You should be coming into your board meetings, knowing what the meeting's going to be about, doing a little bit of preparation. And then be there ready to vote, be there ready to make decisions on behalf of your community. Another responsibility is understanding and being in compliance with your association's governing documents. So this is always kind of a difficult one because the documents, frankly, are so boring to read, right? We all know that. But when you serve on the board, you do have a responsibility to at least generally know what's in the documents. And so what we recommend to boards is about once a year. January is always a good time because we're starting a new year, to take a quick spin through the CC&Rs, the bylaws, the rules, architectural guidelines, articles of incorporation for your association. Really just get the lay of the land on them. And it can be 15 to 20 minutes max for total for all those documents. Just page through them so that you're generally aware of what the important provisions are, how they're structured, so that if something comes up during the year, you know where to look to find out if sheds are allowed or how many days you have to approve an architectural application. All of these things, are listed in these documents. How many board members you should have, when your annual meeting is. Those are things that are typically going to be in the bylaws. So just reading them, understanding them, knowing where to look when questions arise. This is just a responsibility that you have when you're serving on your board. Okay, the next one I'm going to talk about is fiduciary duties. This is the most important thing I'm going to say today. So I just want to make sure that we spend enough time on it. So remember that when you serve on your board as a board member, you have a fiduciary duty to act in the best interests of the corporation. And that's different than acting in your own personal best interests. You have to be thinking what's best for the corporation. So let me give you an example. There may be times where your board is voting on something that you may not personally want, or that you may personally really want it. I can think of one time when I was serving on my board where we were thinking about putting in a tot lot playground in our community. And I really wanted it because at that time I had little kids. And it was something that came before our board. We'd done a lot of research, and ultimately the board decided not to proceed forward with it. And I would be, lying to you today if I didn't tell you that I was really upset that this didn't pass, because there was no place for the kids to play, and it would have just been really fun to go for a walk every night, go to the playground. But as a board member, and I remember I came home from the meeting and I was really upset, telling my husband, gosh, I'm really mad that this didn't pass. And there's so many old people on our board who don't have kids. I was kind of going a little on the wrong deep end. And, he just reminded me to practice what I preach, and I had to kind of take a step back and think about it, after a good night's sleep, I recognized that, okay, I was outvoted on this, but in order to be a good board member and to be acting in the best interest of the association, I shouldn't be undermining the majority of the board's decision. The decision was made, and maybe in a year we'll revisit it and we'll get that tot lot or the playground in our community. But for now, it doesn't help anybody for me to, go around the board, call my friends in the neighborhood that I know that have kids and badmouth the board and, threaten to, picket the front gate, or do anything crazy like that. I mean, we see this in our practice. We see people doing things like this, or circulating a removal petition to remove my fellow board members because I didn't get my way on the playground. That's not acting in the best interest of the corporation. And so one thing that I'll just say on the fiduciary duty is that there are going to be times when you're serving on your board where you're going to be outvoted, and you have to accept it and move on. Some important things to remember for your fiduciary duty are that you have a duty of care is number one. There's really kind of three duties that are very important under fiduciary duty. Duty of care means investing the time that's needed to research board issues, make good decisions, get enough bids so that we're making sure that we're paying market price for things. So acting in a manner that shows that you are taking business care of your association. There's a duty of confidentiality, which is the second duty. And that is, you're going to get the juicy scoop when you serve on your board. That's just how it works. You're going to find out things about people that truly you probably didn't want to know. And one of the responsibilities you have when you serve on your board is that when you come in contact with confidential information, and typically this is going to happen when you are in an executive session, you must keep that information confidential. You have a duty to keep that information confidential. So you can't tell your shuffleball friends, your pickleball buddies, your husband, your walking group, the architectural committee member that's not on the board. You can't tell them confidential information. You have to just keep that to yourself and only talk about that with other board members. And then the last duty is the duty to avoid self-dealing. And self-dealing means you as a board member cannot financially profit from serving on the board. So for example, you couldn't, it's a breach of fiduciary duty, in my opinion, for the board to hire you as a board member and pay you in excess of market rate for some service that you're providing to the community. And you shouldn't be, hiring your son to, be the landscaper at your association. So you shouldn't be benefiting or profiting in any way from your time serving on the board. Now, I'm sure somebody in the audience here today is going to say, well, the Arizona law is kind of loosey-goosey on conflicts of interest. And that is true, frankly, because the Condominium Act and the Planned Communities Act talk about, if there's potentially a conflict of interest by a board member, you just need to disclose it at an open board meeting and you can still vote on it. But what I'm telling you as your friend and as legal counsel that represents associations, don't do this. Don't engage in self-dealing where you're hiring family members, where you personally are being paid for doing something for your board, whatever it is, changing light bulbs. It's not proper in my opinion. And I think that it causes a lot of problems, down the road. And it gives people, a feeling that maybe things aren't smelling good and that there might be something fishy going on. So be mindful of that. So just remember some closing points on fiduciary duty, which truly is your most important board duty that we're going to be talking about today. Is there's going to be times when you serve on your board where you're going to get outvoted. You need to accept it. You need to play nice and support the board. It doesn't mean that you have to, give up on something, but you need to be reasonable and move on. Also, you have a duty of care, a duty of confidentiality, and a duty to avoid self-dealing when serving on the board. Okay, another thing that kind of goes a little bit hand in hand with fiduciary duty is when you're serving on the board, you have to place the interests of the association above your own personal interests when you're making decisions. So a really good example of this would be, there might be times on your board, and this has happened in our association, where, we have a board member who we're talking about the need to increase funds in the association. And we might be saying that we're thinking about doing a special assessment. And maybe the board member says, I can't personally afford a special assessment. And therefore I'm voting against it. Well, the reality is that the association, doesn't have enough money to continue maintaining the association without the special assessment. And although it might be not financially feasible for somebody personally, the corporation needs it. And so, what we always remind boards when we're in this situation is, boards need to work with every resident, and maybe we need to do a payment plan with some of the people that may not have at their fingertips right then and there money to pay a special assessment, especially if it's really large. But we can't have the corporation suffer and potentially have a lack of maintenance, which could lead to more serious problems down the road, ignoring maintenance because, maybe personal feelings of the board members are that they can't personally afford something. So remember, we can't place our interests of ourselves over the interests of the association when we're making board decisions. Okay, let's talk about management companies. So one of your responsibilities when you're serving on the board is to oversee your management company if you have one. And that can be kind of tricky. In fact, we've taught a lot of classes since the pandemic started. I can think of at least 2 where we've talked about the relationship between the management company and the board. And I think anybody who survived the pandemic, like we all have, can tell you that the relationship with the management company during the pandemic was probably more important than any other relationship that we had, with any vendor. As we were getting directives from the state of Arizona, and there were all kinds of health things that we were concerned about, closing common areas, we really had to work together as a team with the management company. And so, thinking about this next responsibility of the board, overseeing and the management company, which in turn oversees the banking for the association, budgets, insurance, utilities, payment of bills, landscaping, taxes. I mean, the management company really is a very integral part of the success of your association. So as board members, there's kind of a fine line between micromanaging your management company to the point that it drives them nuts, and not watching them at all and just letting them do whatever they want. And frankly, every board is different. Some boards have a more active board member or board members who want to be more involved in the day-to-day affairs of overseeing the management company. And other boards take a less active role where they just want the management company to update them on things that are happening and come to the board meetings and make decisions. The one word of caution that I want to say is there's an overzealousness that can be a problem, and then there's an underzealousness that can be a problem. So if you're too overzealous in your management of your manager or your management company, it can lead to burnout of the manager. And frankly, the management company may not want to work with you because you're not letting them do their job. You're not letting them follow their processes. And I think it's just important to communicate with the management company and the manager to determine what's, a happy medium. Where can we both be in a sweet spot in terms of the board members feeling that they are getting enough information and are doing their job overseeing. And the management company can feel that they're, not under the thumb of a board member or board members constantly being scrutinized and being provided negative feedback. So, and then on the flip side of, under overseeing the management company, some boards just let the manager do whatever they want, and maybe some things aren't getting done, or maybe there's been a misappropriation of funds by the manager or the management company, which is very scary for associations. But so you have to be watching the management company, overseeing them, making sure that they're doing their jobs. And it's, like I said, it's a fine line. So, usually having good communication with the management company and trying to determine, what are good policies and practices to have in place so that we both feel comfortable with how this relationship is working. One thing that we sometimes suggest is that every Friday, the manager send an email to the board, updating them on what's going on that week and what their goals are going to be for the next week. And that's just a really good way to stay in touch and to communicate and to give everybody a sense that everybody's doing what they're supposed to be doing in terms of their responsibilities under the management contract with the association. One other thing, just as board members, make sure that you're looking at that board packet very carefully, because that is your oversight of the management company. You should be looking at the financials. You should be looking at the year-to-date budget. You should be looking at homeowner correspondence, listening to what your homeowners are saying at meetings about their interactions with the management company. That's important feedback for you to hear so that you can determine if the management company is in fact, doing a good job for your community. Let's switch gears and talk a little bit about, notice. So obviously under Arizona law, we have special notice requirements for regular board meetings and for annual meetings. So you are required, to have regular board meetings and one annual meeting a year pursuant to Arizona law. The notice that you have to give for a regular board meeting is 48 hours notice to your members. That can be done really any way. You can post it at the property, you can put it on your website, you can put it in your newsletter, you can send out an email. I mean, that's the way that you can notify your members is truly limitless. Annual meetings are a little different. You're going to need to send that out by US mail, not less than 10, not more than 50 days in advance of your annual meeting. So just be aware that we have a special law for associations, the open meeting law that governs open meetings, open regular board meetings, and then also executive sessions. There are special notice requirements that you have to give for open board meetings and for executive sessions. It's 48 hours notice, as I said just a minute ago. And recognize that you do have to have an annual meeting. Some of our associations haven't had an annual meeting since March 2020 due to the pandemic. It's time to jump back into it. And if you haven't already, most have, but if you haven't, you do need to have an annual meeting. And if you need help on that, reach out to our firm. We've got lots of resources. We can help walk you through a virtual meeting if you need help with that. And just know that there are requirements under Arizona law regarding open meetings and annual meetings that you do need to comply with. Okay, next topic we're going to talk about are the documents for your associations. The main documents for an association are the CC&Rs, the bylaws, articles of incorporation, rules, design guidelines. As I said, you need to be aware of them, but then you also have to follow them and enforce them when people aren't complying with the documents. So keep that in mind. It's the management company sometimes will be helping you with this in terms of maybe they do like a site inspection once a week or once every 2 weeks. And then you do have a duty and responsibility to follow up with the homeowners regarding the violations. Another thing to think about is when you have a violation with an owner on their property, what's the process that you typically will follow? So usually we do like a courtesy reminder letter, and then we amp it up and do a violation letter if it still continues. If it still continues after the more formal violation letter, maybe you have your attorney send a cease and desist letter or a requirement that the owner take a certain action. Maybe the attorney calls the owner. Maybe you go to fines. Maybe you start a fine process against them. But remember, if you are fining them, you have to give notice of the violation and an opportunity to be heard before you levy the fine. And the fine also has to be reasonable. Obviously, we also have different other legal remedies in addition to violation letters from the association and the attorney and fines. We can file a lawsuit in Superior Court against the owner and have the judge order the owner to do or not do something. That's a more serious remedy that we use. We also can go to the Department of Real Estate and ask for an administrative law judge to make a ruling on something. So there are a lot of options that you have if you have an owner that's violating the documents. And honestly, the two major violations that we see are going to be short-term rentals right now. And then I would say another typical violations that we're seeing are architectural, especially with the pandemic. Everybody's been doing major renovations on their homes. And so I would say those are kind of the two hot topics right now in terms of violations. But also under this umbrella is unpaid assessments. Really, for the past 18 months, we have not seen that much of an increase in the amount of delinquencies in associations. But just recently, I would say within the past 30 days, we're starting to see more questions from boards, more files being turned over to our office for owners that haven't paid their assessments. And so that's just something to keep on your radar, in addition to violations for owners that may have put a shed in or painted their house the wrong color, or have a short-term violation, short-term rental violation. We're starting to see delinquencies pick up again. And so just be mindful that you don't want delinquencies to linger and fester. So the sooner that you move forward on contacting the owner regarding a delinquent assessment, the better. So the remedies for unpaid assessments are going to be kind of similar to the other violations. Usually you send a courtesy violation letter, then you send a more serious violation letter. With unpaid assessments, we have the right to lien an owner for unpaid assessments, which is a very valuable resource. I encourage associations to be liening early in the process, maybe when the owner is 60 to 90 days delinquent, and then fast track it to your attorney to determine, how we're going to collect on this debt. And it could be getting a justice court judgment against the owner, when we can garnish their wages, their bank account, or their rent if they have a tenant in a property in Arizona. Or we might actually take the more serious remedy of foreclosing them on them. And of course, there's a benchmarks before we can foreclose. The assessment has to be delinquent for 1 year, or they have to owe $1,200 in assessments only. So just keep in mind kind of the problems that boards typically encounter when you're serving on the board are, okay, the owners are violating the CC&Rs in some way, or maybe somebody's not paying their assessments. There are lots of remedies. The key thing that you need to do is act on those promptly. Okay, let's talk a little bit about owners' records requests. So, when you're serving on the board, occasionally you'll get a records request from an owner. And what basically they might specify with particularity what exactly it is they want to see, or they might not know exactly how to ask for records. So we may need to give them a little guidance as to what they might be looking for after talking with them. There's kind of two kinds of owners that do records requests. The first kind of owner is a detail nut, the type of person that just needs to have details on everything. And that person is only doing it so that they can collect information, and they really have no other, motive than they want more information about the association so they can better understand how the processes are running. The second type of owner that requests a records is the owner that's unhappy about something, right? Maybe they received a violation letter and they are convinced that there are 10 other people that have this violation and they are not getting letters. Or maybe they disagreed with the board's decision on something and they want to retaliate, and they're going to, ask for 20 years of records to make our life difficult. The bottom line here is that owners have the right to request records from associations. That is set up under Arizona law and the Condominium Act and the Planned Communities Act. When we receive a records request, we have 10 business days to provide the records to the owner. And just something to think about is the day that the records request comes in, ask for them to put it in writing so they specify exactly what it is they want to see. If it's clear what they want, make sure you're calendaring on your business calendar that, okay, we have 10 business days to respond. If it's a small amount of documents and you can shoot it to them in an email, just do that. Make it easy for everybody. You can charge up to 15 cents per page if they're asking for the actual copies. That's, what the law says. So if they, want to come to the management company's office or the attorney's office, or maybe to a board member's home to pick up the records that they actually want physical copies of, we can charge 15 cents per page. So what do you do if you have somebody that just asks for like a crazy amount of records? So I'm actually dealing with something just like this right now. I've been dealing with it for 2 weeks, frankly. And we have an owner in a particular association who is just asking for unlimited records. I want to see everything. And that just really isn't a reasonable approach for associations. And here's why. And so if you're a homeowner listening to this, or if you're a board member, maybe that's dealing with this problem with a homeowner, it's really difficult to satisfy this type of a person because they don't understand how associations work. So associations that have been around for a while, like maybe 20 years, some of their records may be in digital format. Some of the records may be in old boxes, right, from 1980. We may not even know all the records that we have, right? And so what I try to do when you have somebody that makes a really large records request, like I'd like the past 20 years of open meeting minutes, 20 years of bank statements, 20 years of financial statements, 20 years of year-to-date budgets. What I try to do is I pick up the phone right away and I call them and I say, okay, we received your records request. It's very large. I'm not even sure that we have all these documents. I don't believe we can get these to you in 10 business days. So I've got to give you a more reasonable estimate. And then I confirm whatever the reasonable estimate is in writing to give them, something in writing to protect me as the association's attorney that, hey, we received your records request and it's going to take us longer to compile it than 10 business days is required under the law. But what I really try to get to the heart of the issue is I say, what exactly are you looking for? And I actually had this call with a homeowner's attorney last week. And basically, you know, the bottom line is if somebody, and it came out that the owner was concerned about how the association was spending their money. And I said, okay, I get that. Here's the documents you need to ask for so that we can satisfy what your client wants. Because if we go through, you know, these 20 years of records for all these different categories, it's going to be a lot of information, a lot of out-of-date information, frankly. And it's going to be negatively impact the association because we're going to have the law firm and the management company spend a lot of time and effort collecting the documents. And that's going to cost us, you know, somewhere like $4 or $5 grand to put all this stuff together. And that ultimately hurts the association and it is costing the association more money, which is exactly what you're concerned about, right? So ultimately it was determined with this particular owner that they just wanted to see the last 5 years of bank statements. And so we took a records request that was going to be, you know, a lot of paperwork. And we narrowed it down to, you know, it's still actually kind of a lot of paperwork for 5 years, but we get it down to 5 years of bank statements. So sometimes picking up the phone is a really good idea to, you know, discuss what exactly are they looking for, to provide them with assurances that we're not hiding anything. And we just want to give you the information that you want. And there's some things that owners can't have. Some examples of that would be like attorney's opinion letters for the association. If we're involved in any pending litigation regarding the association, they can't have anything pertaining to that. Personal information about homeowners, like their emails, their personal cell phone numbers. If we have those in our files, we're not going to be providing that. Social security numbers of owners, we're not going to be providing that. So there are some things they can't have, but pretty much everything's fair game. So don't play hide the ball if you're an association. Remember that you have an obligation to provide information under the statute and you're not hiding anything. Remember, we're all volunteers. We're donating our time. We're trying to make the best decisions we can when we're serving on our boards. And if you play hide the ball, it makes people think that you are hiding things and it gives them a feeling of uncertainty and concern. So be really careful on that as a board. You know, you might even want to have your minutes on your website for your association so people can go and read them at any time. Your open meeting minutes would be on the website. Your closed ones, obviously, we couldn't put on the website, and those are not discoverable either. Okay, so don't forget about the requirement that owners, if they make a records request, you have to provide the documents to the association owner within 10 business days. Now, if you're an owner that's listening in on this call, and I hear this kind of often, you'll say to me, I made a records request, the association's blowing me off. They're not giving me anything. Well, what I would recommend in that circumstance is that you need to put your request in writing and you need to tell them that if they don't comply, you know, you will go to the Arizona Department of Real Estate and file a complaint and ask for a hearing with an administrative law judge. It's going to cost you $500 in filing fee. However, you'll get that back if the association, you know, is found guilty in not providing you with the documents. But be careful, don't ask for things that are not discoverable under the statute. So, you know, you have to go back and read the statute. And for planned communities, it's 33-1810. For condominiums, it's 33-1243. So that you know what you are and are not able to request. It's pretty much everything you can have. But like I said, attorneys' legal opinions, anything in litigation, any personal information about an owner, you know, executive session minutes, those are all going to be off limits to you as a homeowner. Okay, let's talk about good communication. So one of your responsibilities when you're serving on your board is to have good communication with your members. Keep them updated about what the board's doing, about challenges, goals, successes. A great way to do that, of course, is at the annual meeting, having a really good presentation, but also communicating with them regularly throughout the year, whether it's through a newsletter, emails, putting your minutes on the website, putting information out there so that if they have questions, they're answered, you know, before they have to come to you and complain. And also it just gives people a feeling of comfort that, okay, I can always go to the website and find the minutes if I'm interested in hearing about an issue. So, all of these different things are a great way to communicate with your owners. And just so you know, the owners that communicate the best, or the associations that communicate the best, have the fewest problems. So keep that in mind. If you want to have a hassle-free time serving on your board, be a good communicator. Talk to your owners, let them know what's going on. Listen to your owners when there's issues. Try to be collaborative and solve problems, and you're going to have a lot fewer problems. Let's see. Just kind of a cursory law that I think you should be aware of is that under Arizona law, you are required to have an audit, review, or compilation every year. And if your documents, typically it would be in your bylaws, require an audit to be done by a CPA, you must have the audit done by a CPA. If you don't have that requirement to have your audit done by a CPA, really anybody can do it. So just some things to think about. You could have a committee, a special committee, like a financial committee, do the audit. You could have the treasurer, you could have the management company. Of course, both the treasurer and management company, it's not ideal because we need to be checking up on them to make sure that, everything is in order. That's why you want to have it be an independent person. But the law is kind of loosey-goosey. I'm not going to lie to you. So unless your documents specify that it has to be done by a CPA, it doesn't. It just has to, an audit, review, or compilation needs to be done. Now, I always have a CPA on a call, especially like the call today where we have like over 125 people listening in, who will say, if an audit, a review, or a compilation can only be done by somebody trained to do those different projects. And I don't deny that, I agree, but the law doesn't say we have to have somebody trained to do it unless it's in the bylaws that the CPA has to do it. So it's loosey-goosey. I'm not going to lie to that to you about that, but it's a requirement. So let's give an example. At the end of 2021, you will have 6 months to have the audit, review, or compilation done by the independent party, hopefully. And then you should have some piece of paper in your association's records by June 30th saying that it's been completed, who did it, what they found, and then just keep that in your books and records. And an owner can request to see that piece of paper if they so choose. Okay, let's talk about budgets. You're probably in budget crunch time. I actually had my board meeting this morning before I had this presentation, and we finally approved our 2022 budget, which is great news. So this is budget crunch time, right? Because you're probably thinking about what your assessment rate needs to be for 2022. And you need to do numbers crunching to determine how much money income you're going to need in order to meet your expenses. So a lot of you, I'm sure, are either have passed your budgets already or are in the process of passing your budget for 2022. If you have any questions or you need help on a budget format, or if your association's in a pickle and you don't know what to do, I had a call yesterday with a board that wants to increase their assessment rate, but they weren't quite sure how to do it so that they could set up their 2022 budget. If you're in that circumstance, what you need to do is look at your association's CC&Rs. Typically under the assessment section, it says how much the board can increase your assessment without a vote of the membership. If you're a planned community and it's silent in terms of how much you can increase it, or maybe the increase is above 20%, which would be unusual, but then you want to look to state law, and state law says that the board can increase the assessment up to 20% of the prior year's assessment in a planned community without a vote of the membership. If you want to go above 20%, you will need a majority of the members to agree to it. Now, I don't want anybody to listen to what I just said and think that I just said that if you're a planned community, you can increase your assessments up to 20% no matter what. That is not what I just said. And every time I teach this class, somebody comes back and says, Beth Mulcahy said that. That is not what I said. So I am going to clarify it again. If you are a condo or a planned community and you want to increase your assessments in 2022, first look to your association's documents. Your association's documents will give you the roadmap as to how to do it. Most often, the board can increase it a small percentage without a vote of the membership. Anything above that small percentage, whatever that number is listed in your CC&Rs, every association is different. You will have to get a vote of the membership. If you're a planned community and your documents are silent on how to increase the assessment rate, or they let you increase it above 20% without a vote of the membership, only in those circumstances does state law kick in. And the Planned Communities Act says that if your documents are silent, on how much you can increase your assessment, then you can look to state law, and it says you can increase it up to 20% without a vote of the membership. So up to 20% of the prior year's assessment. Okay, let's see, insurance, another really important topic. So make sure you're checking your CC&Rs to be sure that you have the adequate and proper insurance that's required for your association. The typical insurances that most associations have would be like a general liability policy, directors and officers insurance, a fidelity bond. These are probably the most common insurance. And you want to look at your CC&Rs to determine the amount of insurance that you need to have. If it's listed, you want to make sure that you're complying with your documents. And it's really important that you're carrying proper insurance for your community, because that's your safety valve in case there's an accident or a problem within your community. You pay insurance so that they can cover any losses that you have or defend you in any lawsuits that you may be involved in. Okay, hiring professionals, having a dream team. Okay, this is really important. So we've kind of covered a lot of different things, but having advisors who can advise you on difficulties that you're going to encounter when you're serving on your board is so important. So having an attorney that practices in the area of representing associations who can guide you and give you good advice as you're navigating different legal problems. Having an insurance agent that you can pick up the phone and call and ask for advice about whether or not to make a claim. Having a management company and management team that works collaboratively with you so that you can maintain your association and solve problems and get things done. Having a reserve specialist, which is a company that helps you plan for long-term capital improvements in your association. These are all really good examples of a dream team. So try to get your dream team in place so that when problems arise, you have them there helping you navigate difficult situations. That's a responsibility of the board, is to find people who can support you, because you don't know the answers to everything. Sometimes you need to bring in a specialist. Okay, don't forget, every year, a couple things that you need to do as a board member. You need to file your annual report for your association with the Corporation Commission. Usually the management company will take care of it for you. Basically, you just Google Arizona Corporation Commission. You type in, there's a button to click that says look up information about a corporation. You type in your association's name and then you check their corporate status. It's usually the same time every year. Like my law firm's is always in February of each year. So I calendar to follow up on it 2 months before, and then I file it with the Corporation Commission. Same thing for nonprofit corporations. Every year you have to file an annual report. Remember, if you don't do this, what will happen is your corporation will lose its corporate status, and that's very bad. That means that everybody in the community is responsible personally for the debts of the association that wouldn't be covered by insurance, and that would be bad. So it's a simple form to file, and we encourage you to please check your corporate status. If you need help doing that, call our office and we'll help walk you through that. Another thing that you need to do is to file state and federal taxes. So don't forget about that. State and federal taxes are due March 15th each year. So you should have a CPA too on your dream team, as I was mentioning before. It's a very simple form, but you are required to do that. We talked a little bit about the annual meeting already, but remember that you have to have an annual meeting every year for your association. You got to do some prep work for that. So you need to back it out. If you know that your annual meeting is in March every year, you should start planning it in November or December. Soliciting candidates, mapping out when you're going to send out the notice and absentee ballot, reserving the room, Contacting a mailing company to help you do the mailing if you have a large number of notices and ballots that need to be sent out. But calendaring out those important dates and planning for it, and then being professional and giving a nice presentation at the annual meeting is one of your responsibilities of serving on the board. And then last but not least, talking about board member responsibilities, just a friendly reminder, please be professional, act in a business-like manner when you're serving on the board. There will be times, no question about it, where you're going to have owners that come and are not nice to you or are not thankful for all the volunteer hours that you're putting in and are going to be very critical of things you're doing. You still have to be nice. You still have to be reasonable. So remember that as you're serving on your board, you got to take a patience pill, because your patience will be tested. And just try to be positive and proactive and responsive to owners when they come in, and explain to them what we're doing, and we're doing the best we can. And we appreciate your feedback versus, getting into it with them. Okay, our last topic, we're perfectly on time, is amending CC&Rs, bylaws and rules. So I have a poll question here in a minute that we're going to be putting up. And one of the questions that we're going to ask you is, has your association amended their documents in the past decade? So I'm just curious, because we have a lot of people on our call today, over 125, and just curious how many of you have amended your documents in the past decade? Yes, no, or if you don't know, that's okay too. So we're just curious as to whether or not you have or have not amended your documents. Okay, so we have 36% have said yes, 53% say no, and 12% say I don't know. Okay, so actually I think this is really pretty consistent with what I thought it was going to be. So we have over half of you that are listening in on this call today that haven't done a significant amendment to your documents in a decade, and it's time for you to do that. So we have a great cheat sheet on this topic. For those of you, we mentioned our cheat sheets here earlier in the presentation, and we have, 60 plus cheat sheets now on different topics. Another one that we have is called Amending Association Documents and Implementing Rental Restrictions, which is obviously a hot topic right now in Arizona. Okay, so let's talk about what are some reasons to amend documents. Get rid of outdated information in there. Clarify things that are ambiguous, unreasonable, clean up the documents so you can actually find things and it's easy to read and understand for somebody who's not a lawyer. Bring it up to speed with what state and federal law says. Maybe you've handled things in your association one way, but the documents say something else. So maybe sheds are prohibited, but you've been allowing sheds in your community for 15 years and you want to take that provision out. Another reason to amend documents is to get rid of provisions in the documents that conflict with other documents. So maybe your bylaws say that you should have 7 board members and your CC&Rs say 3. And it's confusing, which one should it be? In the hierarchy of documents, the CC&Rs would prevail and you should only have 3. But it's really confusing to have that 7 in the bylaws. So you should, amend that to take that out. Okay, let's talk a little bit about, what is the cost to amend CC&Rs? I get that question often when I'm teaching this class. Briefly, the cost could really be anywhere from like $750 all the way up to $5,000. The best thing that you can do is take advantage of our free 15-minute CC&R review. And what we do with that is, if you email me your CC&Rs, your bylaws, your whatever document you want to have amended, rules, we'll look at it for free for 15 minutes. We'll tell you what the procedure is to amend it. We'll give you some initial suggestions on what we think needs to be cleaned up and amended. And then we'll give you a quote as to how much we think it's going to cost for your association and legal fees to amend the documents. So, that's a great way to determine. But the general range is somewhere for, small changes, $750. For overhaul, it's going to probably be somewhere $5,000–6,000 maximum. Okay, let's talk about our 5-step plan, which we've coined and have really fine-tuned over the past 25 years to help associations be successful in amending their documents. So one question I get is, do we have to follow all 5 steps? And my opinion is, if you want to have it pass, yes. So here's, kind of how the 5-step plan works. Number 1, step 1. What does it take to amend the documents? So we need to look at each document that you want to amend, and we need to check the amendment provisions and give feedback back to the board. This is what it takes to amend each document, and every document is different. So, it might be 75% of the owners to amend the CC&Rs. It might be a majority of those present at a special meeting of the members to amend the bylaws. It just depends on what the specific language is. So the first step is, what's the requisite percentage to amend the document? The second step is the longest step. This is where we come up with the changes that we're going to make. So what I prefer is for the board to have our firm take the documents and put them into a Word document format. And we make the first round of changes in a red line format. And then I give it to the board, and then they make their changes and they comment on our changes and give it back to us. And maybe we go back and forth once or twice with changes and communication on the changes. Sometimes the board will give me their changes first, which is less preferable to me, because sometimes I have to change back what they've already changed. But I can do it that way too. So step 2 really is come up with the changes that you want to change. Make it in an easy format so that owners will be able to see what the existing language is, and then red line in a different color, what are the changes that the board is proposing. And those are going to be after getting feedback from the management company and from the law firm that the board is using to help them with this process. Step 3, this is the step that boards always want to skip, but you cannot skip this step, because this is the step where you ask the homeowners, hey, what do you think? So step 3 is educate and soliciting support and feedback regarding the proposed changes. So, in step 2, we come up with the changes. Step 3, we send them out to the homeowners with a comment sheet saying, what do you think? Here's what we're thinking about doing. Can you give us your feedback? Give them 30 days to get back to you. Most people will not respond, but those that take the time to actually read and respond will give us valuable feedback in terms of whether or not something is controversial, whether or not this is something that is not going to fly, whether this is something that's positive for our community, etc. So step 4 is, after we get the feedback from the homeowners that take the time to respond, we develop a plan and a reasonable time frame for the amendment ballot. So are we going to do it in conjunction with an annual meeting, with a special meeting of the membership? How long are we going to give owners to respond? You know your community best. And so some associations, they say, we can get this done in 30 days. And I'm thinking, I don't think that's possible. But then we get it done in 15 days. Some associations say it took us a year last time. So maybe we should say 18 months. So we'll have a dialogue at this point and talk about, how long should we put the ballot out there for? We'll also have a dialogue about what the feedback was from the owners regarding the proposed changes. If something is super controversial, we're either going to throw it out in terms of putting it in the amendments, or we're going to segregate it and have them vote on it separately so it doesn't tank the whole document. Sometimes boards, want to do an all or nothing, up or down on amendments. Sometimes they want to separate them out and have, 3 or 4, I vote yes to amend section 5.1 or no. I mean, we just have to look at what you're changing and what's the easiest way to get the yes votes. So this is what I would call step 4 is strategy time. We listen to the homeowners' feedback. We strategize how long we're going to have the ballot out there. Are we going to do it in conjunction with the meeting? And we try to make good decisions so that we have success in getting this passed. And then last but not least is success, step 5. So after you get the requisite votes that you need, we have to record the documents, whatever, if it's the CC&Rs, we have to record those within 30 days of us getting the final yes vote that we need. If it's the bylaws, they are not recorded. We just have the president and the secretary sign them, and we place in the association files. If it's the articles of incorporation, we have to file those with the Corporation Commission. If it's the rules, we just place those in the files of the association, depending on what the process is. And so step 5 is just formalizing the amendment. So the CC&R amendment needs to be notarized and has the formality of being recorded with the recorder's office, the county recorder's office. Same thing with the articles; those have to be formalized and sent to the Arizona Corporation Commission. And your attorney will help you through this final step 5 process. Don't forget, in addition to the formal things that we need to do, we also need to notify all the owners of the changes and the amendments that they've passed, and then make sure that we're giving new owners a copy of the correct documents with the amendments. So really, that's all. That is our 5-step plan. And I want to just encourage anybody who's thinking about wanting to amend your documents in 2022 to take advantage of our 15-minute free review. And we'll be happy to, give you advice on what we think is the procedure to amend your documents and some things that we think need to be changed. A real common amendment that we're seeing right now is the short-term rental amendment. So if you're one of those associations that is in that position where you have short-term rentals and they aren't going well, and you're thinking about amending your documents to either prohibit them or put more strict time limitations, like it has to be a minimum of 30, 60, or 90 days or a year, maybe even to have a short-term rental. We're here to help you on that too. That seems to be a very common amendment that many boards are wanting to do. Just a brief summary. We went through all the responsibilities of serving on a board. I know there's a lot. I hope it's not too overwhelming. Remember, if you want to go back and do a refresher, check out the cheat sheet that we gave you on board member roles and responsibilities, which has a great overview of really your responsibilities of serving on the board. Then next, we covered the 5-step plan for amending your association's documents. And I told you about our free 15-minute review. And I hope that anybody that wants to amend your documents will take advantage of that by emailing me at bmulcahy@mulcahylawfirm.com. A copy of your CC&Rs or whatever document you want to amend, and asking for the free 15-minute review. Thank you so much for joining us here today for our 11th class of the 2021 Virtual HOA Academy. I'd like to take this time to thank the neighborhood services departments from Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, and Tempe for their teamwork and continued partnership with Mulcahy Law Firm to put together these amazing virtual classes. Be sure to join us for our last class in the series on Friday, December 3rd. So we're having a little date change up. It won't be on a Tuesday in December. We're going to do it a little early so we get ahead of the holidays. So our last neighborhood services presentation is going to be Friday, December 3rd, 2021. We're going to be doing it in conjunction with our firm's free call-in. So we're going to have a free Q&A session for board members, managers, and owners on HOA and condo law. And we're going to call it Bring Your Questions, Big and Small. The class doesn't end until we answer them all. So bring all your questions, bring as many as you have. There'll be no limitation on the number of questions that you bring. To submit your questions and to get more information on the start time, go to our website at mulcahylawfirm.com, click on our seminars tab, and you'll be able to sign up, get the Zoom link, and also submit questions all at once. And be sure to join us on December 3rd because it's going to be a great holiday class and we're going to answer all your questions for free. So thanks everybody for being with us here today. Happy Thanksgiving to all of you, our friends, our clients, our participants who've been listening into our virtual seminars over the past year and a half. We hope you have a wonderful holiday that's safe with your family, and we wish you all the best. Take care, everybody. Have a great rest of the week.